Jamaica, and the Victoria Jubilee Hospital. For those of you joining us online, a very warm welcome. You're in for a treat. They will be debating the moot. Be it resolved that Jamaica should adopt the Caribbean Court of Justice as its final appellate court. At this point, I will invite Team Proposition to introduce themselves, starting on my far right.
Good morning, I am Charnel Henry from the Jamaica Information Service, third speaker for today.
Good morning, I'm Peter Gay Hodges from the JIS, second speaker for today.
Good morning, I'm Twyla Whelan, first speaker from the Jamaica Information Service for today.
Thank you. And now Team Opposition, starting on my far left.
Good morning, my name is Deneve Manning. I'm the third speaker for today.
Morning, my name is Carrie Ann Duffus. I'm the second speaker for today.
Good morning, my name is Shayla Reed, and I am the first speaker for side opposition today.
Thank you, team, an all-female panel, right? So it's gonna be a clash, you can tell, right? And we are joined, of course, as always, by our partners, Jade, who will judge the match today. I'll invite the judges to introduce themselves.
Thank you very much, Aniki. Hello, everyone. Welcome to this match. My name is Jermaine Barrett, and I have the distinct privilege of serving as your chair adjudicator.
Thank you.
Good morning, everyone. My name is Roshana Jarrett, and I'll be your wing adjudicator.
Good morning. I'm Ravon Thomas Matthews, and I'll be your second wing adjudicator.
Thank you very much, judges. And I now turn over to the judges to marshal things. Good luck, teams.
Thank you very much again, Aniki. And welcome again, teams. This house is called to order, and we will just go through quickly some of the rules, and then we'll get started. So in terms of the rules, we're going to be talking a little bit about the time allotments and signals. So the first speaker on either team gets 8 minutes, the second speaker gets 7, the third speaker gets 5, and the reply speaker gets 3 minutes. For the 3 substantive speeches on each team, you have 2 periods of protected time, the first minute and the last minute. So when you've spoken for 1 minute, you will hear a ding. When you have 1 minute left, you'll hear another ding. When you are out of time, you will hear, 2 dings. And, we are very generous here, so we give you 15 seconds extra. So at the end of that 15 seconds additional, you'll hear the continuous dinging of the bell. Thank you, Roshana. She's our timekeeper as well. Now, in between the first and last ding of the bell, that's the first minute, and when you've gotten to your final minute, you are allowed to accept points of information, of course, from the opposing team. Of course, we welcome and we definitely enjoy points of information, so we encourage you to ask points of information throughout. At the point when we get to the reply speech, we will not be allowing points of information. And so with that, are there any questions? No. No questions? All right. So, ladies and gentlemen, at this time, I call upon the first speaker from the proposition side to open the debate. Hear, hear.
Mr. Speaker, judges, all in attendance, good morning. The proposition seeks to support the moot. Be it resolved that Jamaica should adopt the Caribbean Court of Justice, the CCJ, as its final appellate court. To further understand the moot, I will define the key terms. The concise Oxford English Dictionary defines adopt as choose to take up or follow, and final as allowing no further doubt of dispute. The CCJ website describes the 7-judge court as the Caribbean's regional judicial tribunal, which has 2 jurisdictions, appellate and original. Our focus for this debate will be on the court's appellate jurisdiction. The court serves as the final court of appeal in civil and criminal matters for 5 CARICOM countries, St. Lucia, Barbados, Dominica, Guyana, and Belize, which are parties to the agreement and have acceded to the appellate jurisdiction. In its original jurisdiction, the CCJ is a court of first instance, which applies rules of international law in respect of the interpretation and application of the revised Treaty of Chaguaramas. Finally, the term appellate court, according to the Encyclopedia Britannica, are courts positioned above trial courts to review their work and to correct any errors that may have occurred. I'd like to further simplify the moot to read, Jamaica should take on the Caribbean Court of Justice as the last court within the structure of the judicial system that hears appeals. For my presentation, I'll explain how the CCJ facilitates access to justice, how Jamaica can contribute to Caribbean jurisprudence by accession to the CCJ, and how the process of judge selection insulates the court from political interference. My second speaker will highlight the distinguished track record of the CCJ and the cultural advantage the court has. Finally, my third speaker will analyze how the Privy Council's opinion on their position as our final appellate court recommends CCJ accession. At the apex of Jamaica's five-tier judicial system sits the Judicial Committee of the Privy Council, which technically doesn't sit anywhere near here since they are 7,483 kilometers away from here, with judges who are not from here, who've only come once to see here and simply don't know that much about here. The Judicial Committee of the Privy Council, which will be referred to as the Privy Council going forward, is the highest court of appeal for many Commonwealth countries. The court hears appeals from Jamaica's Court of Appeal and may recommend confirmation, overturn, or variation of the judgment of the Court of Appeal. Our Justice Minister, the Honorable Delaware Chuck, in September of last year said, access to justice is very important, and the ministry will do its part in ensuring that this is available to every single Jamaican, wherever they may live or wherever they may go to find it. Well, when compared to the CCJ, the Privy Council has been found lacking in facilitating access to justice, especially as it relates to the costs, especially being prohibitive in the nature to appellants. Now let's break down how much it could cost to bring a case to one of the most expensive cities in the world, and that's London. It's $1,000 for the round trip, $1,000 for a 5-day stay at a relatively cheap hotel, $500 for food we're budgeting and transportation, $200 for emergencies and incidentals, $131 for a short-term standard visitor visa to the UK, if I am approved to get it by the British High Commission. My total comes up to $2,831, which is the equivalent of $435,439.51 Jamaican, and this does not include the legal fees. Now let's compare this reality to that of St. Lucians, who now won't have to think about spending money on most of these things to be present at the hearing of their own appeal, given the country's accession to the CCJ merely 2 days ago. Congratulations, St. Lucia. In addition to reduced costs, St. Lucians also have a chance to have more of their cases heard at a second level of appeal. President of the CCJ, the Honourable Justice Mr. Adrian Saunders, in an address to the Parliament of St. Lucia last year, also made a comparison noting that in the 5 years prior to joining the CCJ, only 6 appeals from Barbados were decided in London. In the 5 years after joining the CCJ, that number tripled, actually more than tripled, to 20. What this could mean for Jamaica, of the 50 to 60 cases accepted by the Privy Council in recent years, means that there could be many more that are rejected by the Privy Council that would actually stand a better chance for acceptance from the CCJ.
Point of information?
Accepted.
When you speak about the actual funding of the CCJ, I would just like everyone to know that every CARICOM country actually contributes to funding it from its government. So is it that you're comparing the cost that comes from the government to the one that comes from the pockets of Jamaican people?
It's not a matter of comparison of cost. What I'm trying to establish is that the Privy Council's process and how the Privy Council represents itself is a barrier to access to justice, really. So, and as a matter of fact, I'm happy you mentioned cost because my second speaker is going to address it. Okay, so Mr. Speaker, access to justice is of top priority for the CCJ as outlined in their 2014 to 2024 strategic plan, especially since they've been doing virtual hearings long before COVID. The Jamaican judge who sits on the CCJ, the Honourable Mr. Justice Winston Anderson, noted in a 2013 lecture that the CCJ uses audio-visual conferencing to conduct hearings, so litigants and their counsel are spared the expense of travel to Trinidad. The CCJ also uploads the recordings of its hearings of appeals to the website that they have, providing transparency and access to the public. The court also has a rule of being itinerant. So this means that the CCJ can decide to sit in any contracting CARICOM state outside of Trinidad. In the Shanique Myrie case, which most of us would be familiar with, I hope, the court heard the first stage in Barbados. The court then heard the matter in Jamaica as Ms. Myrie would not have been able to afford bringing her witnesses to Trinidad. Even more impressive is the CCJ's second rule that allows a party to apply for leave to appeal as a poor person, which allows litigants to access the CCJ without fees and security for costs. In the case of Ross versus Sinclair 2008, the appellant, a blind, poor, elderly Guyanese woman from, Guyana, lacked the means to hire a lawyer to defend any appeal brought. The court considered that the appeal raised important legal issues and got the Guyana Bar Association to appoint 2 of its members to represent both the appellant and the respondent. The court waived all filing fees and heard the case virtually. Provisions like these give me hope for what could be achieved for Jamaica if we adopt the CCJ. Mr. Speaker, while the CCJ has much to offer, so do we. Adopting the CCJ as our final appellate court would also help further our ideals of regionalism through strengthening Caribbean jurisprudence. Jamaica has a lot to offer with respect to the legal fraternity, where our brightest can lend expert argumentation that shapes regional law. And what's region without contribution, cohesion, and collaboration? In fact, Justice Anderson pointed out that the reputation of Jamaica to produce brilliant legal minds is well renowned, having given birth to such luminaries as Norman Manley, David Corr, P.J. Patterson, Frank Phipps, Kenneth Rattray, Patrick Robinson, among many others. The direction of regionalism leads me to my final point: how the CCJ prevents political interference. The Regional Judicial and Legal Services Commission, RJLSC, an independent and non-partisan body, appoints judges and staff of court. The court's president is appointed based on the recommendation of this commission. If the heads of government do not appoint the president selected by the RJLSC by at least a 75% vote, then heads of government must request another nominee from the RJLSC, not one of their own, because the CCJ was not designed to be puppeteered, Mr. Speaker. The CCJ is a microcosm of the macro ideal of Caribbean unity. Its very existence was built on securing the integrity of our attempts at establishing our identity as a region. The court's mantra holds true: your people, your region, your court. The CCJ was always ours and has been waiting patiently for us to act like it by acceding. I think it's time we did that. I rest my case.
Thank you very much for that speech. On behalf of the proposition team, we now call upon the first opposition speaker to respond and advance the case on behalf of their side. Hear, hear.
Chair, adjudicator, timekeepers, and members of this audience, good morning. Side proposition talks about costs in relation to the CCJ. But let it be known, adjudicators, that Jamaica is currently paying $27 million towards the $100 million trust fund for the establishment of the body. Proponents of the CCJ say that this will go into perpetuity because the court will make its own money. But how can we be assured of that fact? Won't we have to spend more money now if we are to use the CCJ in its appellate jurisdiction? And how are we going to fund the CCJ, in particular with our disadvantageous situation, right? Unlike the Privy Council, which we do not have to spend even a red cent for. Adjudicators, side proposition also spoke to the fact of location. Let us speak directly now to the relevance of the Privy Council. In this day and age, similar to the CCJ, the Privy Council also uses virtual means to hear their matters. So we no longer have to say that a hindrance to utilizing the Privy Council is location. In addition to that fact, we also have several interest groups, such as the London Group, which works closely with the Independent Jamaican Council for Human Rights to provide free legal representation in England. The closing of the circle of, not accepted at this time, the closing of the Circle of Independence and sunset of British colonial rule is the pipe dream that T proposition is trying to sell us this afternoon. Chief Adjudicator, my opponent's misguided notion that it is in the best interest of Jamaica that we adopt the Caribbean Court of Justice as our final appellate court is one that we, side opposition, must disabuse you of. The moot that lies before us this morning highlights the importance of good governance in the selection of a judicial institution. No discussion can be had about the judiciary without emphasis on the proper administration of justice. Lord Hewart, the then Chief Justice of England, once said, "It is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done." Therefore, my opponents, should we sacrifice the proper administration of justice under the guise of closing the circle of political independence and promoting regional integration? Or should we do what is in the best interest of our country to ensure that we have an independent and virtuous judiciary? We, the opposition, are resolute in our disagreement with the moot and advance the belief that Jamaica should not adopt the CCJ as presently constructed as the country's final appellate court, but maintain the current status quo of utilizing the Privy Council for the promotion of national sovereignty, national identity, and independence within the judiciary. I, the first speaker of side opposition, will highlight the importance of national identity in the administration of justice at a court of last resort. My second speaker will discuss the legitimacy and the judicial independence of the CCJ, not accepted at this time. Not accepted at this time. While my third speaker will speak to the practicability of adoption and utilization of the CCJ in its appellate jurisdiction. Adjudicators, if there is to be a regional court of last resort, then that court will be representative of us, the Caribbean people at large, and of us, the Jamaican people. But who are we really? Is there really a Caribbeanness or a Caribbean we that can be relied on as the basis for the application of social context in the administration of justice? You see, my opponents, the Commonwealth Caribbean has perhaps one of the largest conglomerates of small island developing states in the world that is connected by a geographical location and shared history of slavery. However, since the independence of many British colonies, the deep historical and geographical link amongst the Caribbean countries has been weakened due to the major differences in each country's development. In fact, economically, Barbados and Trinidad compare reasonably favorably with some first world countries, while Belize and Jamaica are among the poorest countries in the Western Hemisphere. There's also a stark difference in the legal sphere, as countries such as Guyana and Barbados are further ahead in their legislation.
Point of information.
Accepted.
Thank you. Would it not stand to reason then for us to actually develop this sense of Caribbean nationalism, for us to have a body that represents it with representatives from each CARICOM state or from a good portion of them?
Well, yes, we want to encourage regionalism. This is why we have been utilizing the CCJ in its original jurisdiction. That does not mean we have to utilize the CCJ in its appellate jurisdiction. I continue. The truth is, the differences in each Caribbean country's culture is well known and clearly shown. Chair Adjudicator, every man has been and is out for himself. The integration process of the Caribbean has been fragile. Not accepted at this time. The integration process of the Caribbean has been fragile with a weak institutional basis. So why should we adopt the CCJ in its appellate jurisdiction, knowing that there is no solid track record of CARICOM building viable regional institutions outside of UWI? Do we really want another 1 from 10 leaves not situation, or do we want stability in our judicial system? Side government might argue that we must turn to the CCJ because the Privy Council lacks knowledge of our social and cultural values. However, Chair Adjudicator, this opinion is misinformed. The perception that one must be born from a certain country to be aware of its social values is false, as representation in the judiciary does not equate to the nationality of the judges. Over the years, the Privy Council has made several strides to ensure that all appeals from the Commonwealth Caribbean are being judged fairly. In fact, when hearing Caribbean matters, the Privy Council has drawn on cases from the region that they have tried as it is necessary and even brought on superior judges from the Commonwealth country that they are trying to hear that matter, such as the inclusion of Sir Shadi Lal from India in a matter. My opponent, it is the breadth of territories and cases covered by the Privy Council and the nearly 200 years experience that their judges bring to bear that justifies why Jamaica should utilize the Privy Council. The Privy Council has over 15 judges within their pool from which to utilize in the hearing of matters, in comparison to the CCJ's 7 judges, who only one is Jamaican, by the way. Should we rely on the one Jamaican judge on the court as our saving grace to ensure fairness and representation for Jamaica in the administration of justice? I think not. Adjudicators, the Jamaica's court of last resort is not one to be decided on mere regional integration, but on the pursuit of the proper administration of justice. Thank you.
Thank you very much for that speech. I now call upon the second proposition speaker to respond. Hear, hear.
Mr. Chairman, honorable judges, I raise in furtherance of my team's argumentation in favor of the moot. Before I do so, however, I wish to address some issues raised by the opposition's first speaker. My worthy opponent, do not mislead the people. We have paid in full into the seed fund the $100 million that was seeded by CARICOM countries to fund the CCJ. It means that it was seeded to fund the CCJ over a period, and Jamaica has paid in full. Also, you mentioned the judges and how many Jamaican judges. There has to be a fair representation of judges, and of the 7 judges of the CCJ, 1 is Jamaican. Let's not be too greedy. That said, we deem it important at this juncture to underscore the fact that the CCJ has proven to be a world-class quality court in its 22 years of existence. This is evidenced by the acceptance of the court into the International Consortium for Court Excellence, not at this time, an international network of courts and other organizations with expertise in court and judicial administration, whose goal is to apply the international framework for court excellence. This is a quality management system designed to help courts improve performance and build public trust and confidence. The framework consists of, among other things, 7 areas of court excellence and 11 global measures of court performance. So essentially, it's akin to an ISO standard for jurisprudence. You may go ahead.
Okay, so my question is in relation to the funding. So the trust fund that is in place for the CCJ is a loan from the Caribbean Development Bank, which we are currently paying back for. And the argument is not about the money that we're only paying now, but what will we pay in the future, given that Jamaica has so many appeals to the Privy Council and will transfer that to the CCJ?
My understanding of a seed fund is that the funds are put forward, and it is the interest from the fund that will fund the court over time. Let me add for your edification, my opponents. The CCJ is a unique court in that its judges are only appointed after a competitive and rigorously transparent selection process. In an address to the Jamaican High Commission in London on the benefits to Jamaica and the Caribbean of full accession to the CCJ in 2013, the earlier mentioned Justice Anderson said that scholars worldwide have been heralding the CCJ as an international model court. As first speaker outlined, the main feature of the judges' selection process is that it is independent and non-partisan. Justice Anderson further expressed that the British Academy, the UK's National Academy for the Humanities and Social Sciences, funded a research project in 2008 which found that the selection process of judges of the CCJ should be used as an international model for identifying judicial candidates of unparalleled caliber. Jamaica should really avail itself of this fine example of excellence in Caribbean jurisprudence at all levels. I urge you, my opponents, to consider with me for a moment how the law lords of the Privy Council, even by their own admission, are culturally distant from the regional context. To sit in a chamber of Middlesex Guildhall and try to appreciate the construct of Kingston city streets have proven to be challenging to the Privy Council. I will paint you a very vivid picture. Populist English judge Lord Alfred Denning, who served for 20 years as head of the UK Court of Appeals, in one of his many publications explained how the law lords at Westminster, in attempting to arrive at a ruling on a murder case in Jamaica, heard evidence that the accused entered a tenement yard in an inner city community and disappeared. Would you believe, Mr. Chairman, that the members of the Judicial Committee could neither fathom nor grasp the concept of a tenement yard? What a precare when a man's fate lies within the hands of ill-equipped decision makers. This is not to say that the decision makers do not recognize their shortcomings in that area. On the contrary, on repeated occasions, members of the Judicial Committee have beseeched overseas territories to let this cup pass from them. Third Speaker will expound. In the case of Surratt versus the Attorney General of Trinidad and Tobago, Lord Bingham tried to persuade his colleagues that, in his words, and I quote, weight should be given to the judgment of the Trinidad and Tobago courts. A judge sitting in a local constitutional environment in which he has grown up and with which he is familiar is likely to have a surer sense of what falls within the purview of the Constitution and what falls beyond than a court sitting many miles away. For this reason alone, in the absence of manifest error, the board should be slow to disturb the unanimous conclusion, not at this time, of the local courts on a question of this kind, end quote. So talk truth, Mick. Do you really believe what I say? Well, I am sure the judges of the Caribbean Court of Justice totally understand. And if they don't, the Jamaican will teach them. But alas, I digress. Ladies and gentlemen, I leave this with you. We are already paying for the CCJ. Our contribution to the seed fund represents a significant investment of taxpayers' money in a facility that we do not utilize on the one hand, the appellate arm, and hardly utilize on the other hand, the original jurisdiction. So we order the manufacture of the bus, we get others to help us buy the bus, we appoint the drivers, we determine who else can drive the bus, we sit on the bus committee, but instead of taking the bus, we choose to walk to our destination. Let me explain my opponents. In April 1970, the CARICOM heads of government in Kingston basically ordered the manufacture of the bus by tabling a proposal to establish the regional court. Trust fund was set up to finance the court, and at another CARICOM heads of government in Mobay, in Jamaica, the agreement to establish the fund was signed. We got others to help us buy the bus. Justice Anderson, who was earlier mentioned, is not only Jamaican, but the youngest judge to be appointed to the CCJ. We drive the bus. The Regional Services Commission, which selects judges, has our Chief Justice, Brian Sykes, Her Honor, Madam Hilary Phillips, noted attorney, and noted attorney Jacqueline Samuels Brown, King's Counsel. We sit on the committee and we determine who else drives the bus. But we do not use the CCJ as our final appellate court, although we've contributed 28.7 million, or just about 4.4 billion Jamaican dollars at today's rate. We choose instead to walk, although the shiny bus is driving around, picking up and setting down Bajans, Guyanese, Dominicans, Belizeans, and now St. Lucians. Folks, we are already paying for the CCJ. Let us now realize a return on our investment for money, talent, and time. I rest my case.
Thank you very much for that speech. We now call upon the second opposition speaker to respond. Hear, hear.
Esteemed adjudicators, ladies and gentlemen, my fellow team members, my worthy opponents, good morning. The proposition has harped on the fact that the Privy Council is a great distance away from Jamaica, and as such, access to justice is far removed. But let us not fall victim to that myth, ladies and gentlemen. My first speaker would have already established that we are living in the 21st century where the use of technology has proven that distance is no longer a major issue. I think that the JIS, being a strong advocate of technology and innovation, would appreciate that. With that being said, ladies and gentlemen, please do not misconstrue our stance. Team opposition is not saying that the CCJ is not a fine court. After all, we do utilize the court in its original jurisdiction. What we are saying is that the CCJ is not the best fit to be Jamaica's final appellate court, and I'll tell you why. Side government will have us believe that the CCJ being housed within the region is a benefit, that it's more knowledgeable of our culture as opposed to the Privy Council, but that is farthest from the truth. The regionalization of judicial independence does not provide impartiality or protection from political intrusion. It is said that the CCJ operates independently of the member countries, and they may very well be trying to accomplish that, but there is no way to fully guarantee that the court is not influenced by political agendas when the very composition of the judges themselves is determined by the heads of state of the CARICOM countries. According to the official CCJ website, there are currently 7 judges that sit on the panel. The president is appointed by a majority vote of the heads of states of CARICOM countries. And yes, the other 6 judges are appointed by the Regional Judicial and Legal Services Commission. However, the chairman of the commission is also appointed by who? That's right, majority vote of the heads of states of CARICOM countries. My opponent's perception breeds doubt. If it walks like a duck and quacks like a duck, it's going to be very difficult to convince people it is not a duck. With the CCJ, there will always be that risk of political appointment of CCJ judges. Our closeness to each other, my opponents, is what creates that risk. The Caribbean small size is a network of friendships, kinships, and acquaintances. Furthermore, not accepted at this time. Furthermore, the very legal document that establishes CCJ and grants its power is merely an agreement which can be amended by, yes, you guessed it, a majority vote of the heads of states of the member countries. What would happen if one day, not accepted at this time, if one day all these countries decide to withdraw from this agreement, the court would cease to exist. There is no such risk of political interference or ceasing to exist that can occur with the Privy Council. The Privy Council is objective and impartial. The court is far removed from the Caribbean, and so its decisions are made solely based on the law. That is why it is trusted. Which brings me to my next point, Mr. Speaker. For any legal system to prove its legitimacy, not accepted at this time, there must be evidence of trust in it, and the CCJ has not existed long enough to elicit that trust and confidence in its appellate system in comparison to the Privy Council. The mere fact that in its 22 years of existence, only 5 countries have adopted the CCJ in its appellate jurisdiction is a sign of the lack of trust that the Caribbean people have in the institution to fulfill this appellate mandate. Go ahead, third speaker, POI.
I wanted to interrogate your argument about political interference, especially as it relates to the fact that the nominee rests with the commission. At the end of the day, the nominee has to be selected by the commission. So what is your argument exactly against that?
You misunderstand side government. I'm not saying that the nominees are not appointed by the commission. What I am saying is that there's a perception that there might be political interference because the chairman of the commission is appointed by the members, the heads of states of government. I continue. Ironically, Trinidad and Tobago, the country that houses the headquarters of the CCJ, still uses the Privy Council as its final appellate court. So much for distance. Why is that, my opponents? We have to ask that question.
Point of information.
Not accepted. It goes without saying that the public should be able to trust the judiciary. We entrust each and every judge with significant power over our lives and liberty. Can we honestly say that we fully trust this appellate system beyond a shadow of a doubt? Experience matters. Even in our applications for a job in the public sector, one of the biggest stipulations to get the job is years of experience. Why? People trust experience. Experience says, I know what I am doing. The Judicial Committee of the Privy Council has it's been in existence for 190 years. So let's look at the stats. During the entire lifespan of the CCJ, that is between 2001 and 2023, the CCJ has only heard about 260 appellate cases. For that same period, the Privy Council has presided over 1,000 appellate cases. It cannot be denied that experience and credibility of the Privy Council not accepted, adds value to our judiciary and brand Jamaica. It is a statement of fact that our foreign investors trust the Privy Council. Our very own Honorable Minister of Industry, Investment and Commerce, Senator Albin Hale, said, and I quote, "A big part of the attractiveness for foreign investors to Jamaica is that inter alia or judicial process ends at the London Privy Council." So team government, you may say, then why not give the CCJ a chance to prove itself? No, my opponents. The justice and liberty of our Jamaican people are far too important to be experimented with. If we truly wish to become a republic, then it is imperative that we establish ourselves as strong contenders in the global judicial sphere and retaining the Privy Council that already gives our investors that confidence is how we are going to do that. There are just too many doubts and political perceptions that may surround the CCJ and its appellate jurisdiction. We cannot afford to be caught lacking. We must consider the best interest of the Jamaican people. Retaining the Privy Council encompasses our vision of making Jamaica the place of choice to live, work, raise families, and do business. Thank you.
We thank you so very much for that very passionate presentation. Hear, hear. Now we call upon the third proposition speaker to advance a response. Hear, hear.
Mr. Speaker, members of the audience, my worthy opponents, and my esteemed colleagues, good afternoon. I have to start by first correcting some misconceptions that the side opposition would have linger in the room, and that we cannot afford for, as the Jamaica Information Service, the source of credible government information, allow for these to be the things that you remember. Now, let me first say that it is not a chairman that the commission has, it is a president. And even after it needs a heads of government, 75% vote for that president to be appointed, if he is not, they cannot simply, this is the heads of government, just recommend somebody else. It has to come from the legal council that recommends all the persons to be appointed. It's not the prime minister of this country and that country that decides. Okay, also, where it concerns the funding of the CCJ, once we have paid our portion, which we have in full, there is nothing more for us to pay to use the CCJ as a country. Now, a court of your own is necessary if you're going to have the full benefit of what a final court can do to transform society in partnership with the other two branches of government. Ladies and gentlemen, these are not my words. They are the words uttered verbatim by Lord Hoffman, a member of the Privy Council, at the annual dinner of the Trinidad and Tobago Law Association in 2003. Sentiments like this go as far back as 1838, when Lord Bruman expressed in no uncertain terms that it is obvious that from the mere distance between the colonies, which would be us, and the immense variety of matters arising in them foreign to our habits and beyond the scope of our knowledge, that any judicial tribunal in this country, referring to England, must of necessity be extremely inadequate as a court of redress. Now, additionally, September 2009, Lord Phillips, another member of the Privy Council, complained that a disproportionate amount of the time of his judges, more than 1/3 of their time, is spent on matters of the Judicial Committee of the Privy Council. And he politely nudged the Caribbean states to go to their own court. Now, it is court singular, not courts plural. One. There are many other instances like these where the Lords of the Privy Council have said it would be better for us, the Caribbean, to rule and preside over our own appeals. You see, in times of old, the king would hear the petition of his people. But as British colonies colonies grew and his subjects increased in number, the king established the Privy Council to hear the petitions of his colonial subjects, his people, on his behalf. Are we that people that want to bring our petitions to a king in a foreign country? I say we need to emancipate ourselves from the mental shackle that foreign things better than yard. Now, retired judge of the Belize Court of Appeal, Douglas Mendes, said, you cannot, as an independent nation, call yourself independent if you must go to a foreign court as your final court of appeal. So we have, on the one hand, we're being lambasted for having a foreign final appellate. And then on the other hand, we're being told to use our local court of appeal. Now, what Jamaica is doing here is hanging on to our relationship out of the comfort of familiarity, even when our partner is trying to shake us loose. Have we no shame? My opponents, Jamaica should adopt the Caribbean Court of Justice as its final appellate court. Now, the first speaker of side opposition did say that they mentioned something about political independence. Let me explain something to you. The Privy Council, well, Britain never really gave us political independence. The Privy Council, in being Jamaica's final appellate court, has too much rule and power over us. So let me pull back the curtains and show you something. Upon the creation of our Constitution, Britain left its tentacles in our laws through things they call general saved law clauses. This protects and entrenches and preserves laws, punishments, and penalties that existed pre-independence. Essentially, colonial laws, penalties, and punishments cannot be challenged as being unconstitutional, even if they are. So fast forward now, several decades later, even though Jamaica got rid of the general save law clause, we still held on to special save law clause around death penalty, buggery, and laws that discriminate against persons based on their sexuality. Now, protecting these laws just paints a grim future, not just for persons of the LGBTQ community in Jamaica, but for Jamaica itself, as the world is going to move past us, where these laws concerning human rights evolve. Listen, the Privy Council even told us how to go about appointing the Caribbean Court of Appeal as our final appellate court. It's simply a change in constitution. Now is the time. Now is the time to accede to the Caribbean Court of Justice while we are on the road to republic.
We thank you for that spirited presentation. We now call upon the third opposition speaker to present the final substantive speech on behalf of their team. Hear, hear.
Members of the adjudicating panel, timekeepers, scorekeepers, my worthy opponents, members of the audience, good morning. Honorable judges, let history not remember this generation as the ones that made judicial decisions based on political biases. Justice is too precious and scarce a resource in Jamaica to be tainted. My second speaker spoke of Judicial Privy Council from a strategic business point of view. From foreign direct investments to Jamaica is at stake and our country will incur financial losses. Investors are more confident in the Judicial Privy Council, the Judicial Committee of the Privy Council, because issues are being decided by judges who are not personally or have an interest in the outcome of these litigations, as they do not live in the jurisdiction. This strategic alignment is a unique position for Jamaica, which seeks to secure larger stakes in commercial foreign investment and export. In short, investors see rulings from the Privy Council as free from political influence and bias. Honorable judges, it behooves me to the point that side government has not adequately addressed this in their policy, nor the stance from my first speaker regarding the fact that the judge must be independent of political influence, including the appearance of political influence, for the law to be upheld. This is critical in deciding justice and maintaining stability and order in a civilized society. At this point, side governments, adoption of the Caribbean Court of Justice would be self-destructive. And for what? To appease the facade of regionalism? The average Jamaican is being asked to pay too much for too little. Now, side government comes to the public with ill-informed policies that reek of a special kind of nationalistic ignorance. And this keeps the population in darkness about the dangers of leaving the Privy Council. So, let's do a brief synopsis. 3 sources of law: the Constitution, the common law, and the statutory legislation. Let's speak to the Constitution. In IJCHR 1998 Limited and others versus Marshall Burnett and Attorney General of Jamaica, 2004, the Governor General of Jamaica gave an assent to 3 bills to abolish the right to appeal to the Privy Council, to substitute with the Caribbean Court of Justice. The question to be decided was whether the procedure to be adopted and enacted into legislation complied with the requirements laid down in the Constitution. They did not. My worthy opponents have danced around the issues that the CCJ is not entrenched. It risks the governments of...
Point of information?
Not at this time. So they've danced around the CCJ, and it is not entrenched, and this is a risk that the governments of the contracting states can alter the CCJ agreements so as to weaken the independence of the court and erode the protection of the citizens and entrenching a form of tyranny. This attempt to align ourselves with the CCJ...
Point of information?
Not at this time. Was found to be unconstitutional and void. Go ahead.
It is that very same ruling that the Privy Council, once they heard the appeal, gave us the instructions of how to get rid of them and abolish appeals to the Privy Council and appoint the Caribbean Court of Justice as our final appellate court.
All right, so even if, our honorable judges, even if we ignore what side government has been saying, the fact is that they're blinded by nationalism. They're blinded by the zeal of letting the government pause. And let's review the optics. Trinidad, the home of the CCJ, does not use the CCJ as their final appellate court. My worthy opponents, it is shameful that you ask the average Jamaican to make decisions without being properly educated on the issues at hand, to give up their entrenched constitutional rights for a shifting sand of the Caribbean Court of Justice. Honorable judges, the issue is why? Why would we leave our institution of justice from a wealth of jurisprudence and a vast legal reasoning to an institution with jurisprudence of only 18 years? 18 years, judges. My grandmother has shoes older than the jurisprudence they wanted.
That's a fine note on which to end. Thank you so very much for that presentation. We're going to pause now for 1 minute to allow you to put the final touches on your reply speeches. At the end of the 1 minute, we will resume with the presentation from the reply speaker representing side opposition. Hear, hear. the end of your 1 minute break. And this time I call upon the reply speaker from the opposition side to present their final submission in this debate. Hear, hear.
Adjudicators, side proposition would have us believe that deeper regional integration needs legal framework. We might agree to a certain extent that yes, the CCJ is important. However, we must make the distinction that we believe the CCJ should be used only in its original jurisdiction as it is currently constructed. Side opposition also referred to the fact that we have attempted to make the CCJ our final appellate court and said that it was our the Privy Council's decision that said this is how we go about the court. In fact, if you do read the case of IJCHR versus Marshall Burnett, you will find out that it is the government of Jamaica which did not take the right judicial procedures to put this court in place. The issue at hand in that particular case was judicial independence, and speaking to the fact that the CCJ was one that did not have enough. As a matter of fact, the judge in that case said there is no doubt that the Privy Council is impartial. So why should we now call it to question here in this debate? In addition, side government. Familiarity breeds contempt. The close proximity of the CCJ does not mean we will now have fairness in justice. As a matter of fact, this will lead to bias in different cases. Let us not forget that being so close in this particular region means we know one another, we know our cultural values, and this requirement for indigenous court might be so indigenous to the point that it's to our detriment. We not even recognize the fact that, yes, we are talking about the knowledge of the CCJ judges and what they know locally, but the issue is with the beyond. With the beyond, they are not aware of the international human rights law. As a matter of fact, we do speak to the hanging court that is associated with them. The savings law clause. That side proposition is the same one the CCJ has repeatedly complained of in the case of that you mentioned, Surat and AG, to be removed. So the Privy Council is actually the one that has been protecting the savings law clause. They have not called to question the use of the savings law clause, unlike the CCJ, which is overstepping its role of trying to change law. Then you speak to the cost of the CCJ. Yes, we have spent that 27 million, but it's not the concern of what we have spent already, but what about the future? You spoke to the fact that a Privy Council judge said that we take up 1/3 of the burden, the workload that they deal with at their court. That same workload will now transfer to the CCJ. And what does that mean? More funding for the CCJ, which we cannot provide. Lastly, we speak about the heads of government when it comes on to deciding who is the president of the CCJ. However, we do recognize, even though the commission can make a recommendation, the final say comes with the heads of government. So are we going to continue this process of going back and forth? In fact, you will now have to concede to what the heads of government say and decide on a judge from there.
Thank you. Thank you very much for that speech and for concluding the case on behalf of Team Opposition. We now call upon the reply speaker from the proposition side to conclude the debate as a whole. Hear, hear. Hear, hear.
My worthy opponents, listening to you reminds me of listening to a disillusioned and battered partner who simply doesn't understand what it means to let go, who simply doesn't understand that they can actually do better on their own. Because one of the first things well, not first really, but a very critical part you mentioned has to do with the CSME and how the CCJ actually forms a really core part of the CSME and how it was formed. You mentioned the legal framework and that why do we need the legal framework within the Caribbean? Well, that is what sets it up. Our ability to move within CARICOM needs laws to back it up, and this is how the CCJ functions. You also mentioned the London Human Rights Group, usually facilitating human rights cases. Actually, it's mainly death penalty cases that they take, and Jamaica rarely submits death penalty cases. How could you also describe Caribbean nationalism as a pipe dream? That's actually particularly hurtful to our ideals as a country because everything starts from a thought, from a seed. Emancipation started from a seed. Independence started from a seed. It cannot be constituted and summed up merely to just a pipe dream. Also, access to justice. The filing costs from the judicial from the Privy Council, essentially, are far more expensive than the CCJ's filing costs comparatively. So even if they have the virtual provision, it's far more expensive to pursue cases with the Privy Council. In addition to that, you also spoke about the slow accession. It took St. Lucia 20 years. Each country has a different constitutional setup, and so the timeline for adjusting that and having a final appellate court is a serious process. So it's going to take some time. There are complications there that you can't account for. You mentioned Vision 2030. I need to add that access to justice is a critical part of sustainable development goals, and we have outlined at great length how much more the CCJ facilitates access to justice. My opponents, audience, I need you to understand also the critical aspect of understanding sterility and what it can do when considering law. If you have a judge that is far removed, yes, it may seem more impartial, but circumstances are not understood, and this can cause serious issues with deliberations. So that's a completely missing point. You need a degree of familiarity to help carry over in the interpretation of the law and the application of the judgment. In addition to that, the facade of regionalism that you mentioned is what offered us the degrees to come up here and have the audacity to lambast CARICOM and talk about what they aren't doing or how CARICOM looks. The reality is it has afforded us SEDIMA, it has afforded us UE, it has afforded us so much, and it has afforded us the CCJ now in this opportunity as a final appellate court. We have the original jurisdiction as well. We've already signed on to that. Why is it that we cannot also sign on to the appellate jurisdiction when it functions perfectly? All its rulings are finals. It is internationally recognized. It is more than a worthy option. We cannot fall prey to the poisonous and disillusionment of team opposition, and this is why we are propelling and we are resting that we should adopt the CCJ as the final appellate court. Thank you.
Thank you very much for that fine speech and for concluding what was a most exciting debate. Hear, hear. I now invite the moderator to take us to the break. Aniki Clark.
Thank you very much, Jermaine. That was indeed a spirited debate. Let's give them another round of applause. And at this point, we take the break, and the judges will deliberate. I would not want to be them, to be honest. The arguments were on both sides, very strong, very persuasive, and we await the decision. We take the break at this point. Thank you very much.
touch you and make you tingle with delight. Financially, I'm a boy, but when it comes to loving, I'm alright. Alright, alright. Don't show me what your friends are wearing. I really don't want to see. Oh yeah. Don't tell me what your friends are buying. 'Cause money doesn't grow on trees. Tell me about the things that excite you, that makes you tingle with delight. Tell me where to hold and touch you, so when it comes to loving, I'm alright, alright.
Ladies and gentlemen, welcome back. We seem to be on a marathon this morning today because here we have just witnessed another enthralling debate about an issue that is of national significance at a time like this when we're talking about constitutional reform. Yes, soon to come up on the agenda of the discussions and national discussions will be the question about whether or not we should retain the Privy Council as our final court of appeal. And here we had two teams, titanic teams I thought they were, we thought they were, debating that very same issue. I think they did so very well that they deserve a thunderous round of applause. Now, I will say, they gave us judges a warm time. And the final result is one that reflects not a unanimous decision, but a split decision. A split decision. Let's talk about what transpired. The proposition team tells us that we should end our relationship with the Privy Council for a number of reasons. They speak about the distance that exists between ourselves and the Privy Council, not just with respect to physical distance, but also cultural distance. They are disconnected, they say, from our realities. They quantify the cost that is involved in obtaining justice from the Privy Council in a very exact fashion and say, in addition to that cost, are costs related to legal fees and so forth that have not yet been computed. And they juxtapose that to what the costs are for obtaining justice from the Caribbean Court of Justice. They really speak about the Caribbean Court of Justice and the nature of it as being an itinerant court, a court that is closely embedded within the Caribbean cultural context. And they say it is, quite frankly, insulated from political manipulation and mismanagement. Opposition, on the other hand, tells us that they're not so sure about this claim that it is insulated. And they make a case that it would inform us as judges that there may actually be instances in which, based on the architecture of the Caribbean Court of Justice, it could be the victim of political manipulation. They speak about the Caribbean heads of government needing to appoint the president. They speak about the closeness, the fact that it's embedded within the Caribbean region makes it susceptible to manipulation. They further contend that there is a question of trust, and that trust is important with respect to which of the two courts to choose. They say the Privy Council has existed for over a century, the Caribbean Court of Justice not so long. And there is certainly within the Jamaican population not as much confidence within the Caribbean Court of Justice. They also point to the fact that international or foreign direct investors would be a little less inclined to come and invest in Jamaica were we to move to the Caribbean Court of Justice. Now, ladies and gentlemen, we thought that some of the arguments presented in this debate needed a little bit more development, a little bit more work. And we know that the teams are constrained by the limitation of time, yes? Our timekeeper was on the ball, tapping the bell at the time to signal that they're out of time, and we felt that there was a lot more to be said in developing these arguments, yes? So one of the arguments that we thought that needed more development were arguments surrounding whether or not investors are likely to come and invest in Jamaica were we to move to the Caribbean Court of Justice. We heard what sounded to us as being a sort of an assertive claim, but we wanted to hear evidence, for example, of other countries of them losing investment because they have acceded to the Caribbean Court of Justice. Yes, wanted to hear some practical examples to convince us that that is in fact so, beyond highlighting a quotation from a politician. We also thought that claims surrounding the political manipulation and the misadministration of laws, we wanted to hear a bit more evidence about how it is that the Caribbean Court of Justice, as opposition contended, is doing not as good a job as the Privy Council in getting its rulings right. Yes, as assessed by maybe some international body or so forth. We were pleased to hear side proposition tell us about the International Consortium of Judicial Excellence. I hope I got that right. And that they have stamped their stamp of approval on the CCJ as a mark of its own internal excellence, and that should give Jamaicans confidence in acceding to its appellate jurisdiction. The question of cost was also significant, and this is going to be the final point. I know you've been waiting for a while. The question of cost was significant. We heard, and I think both teams agreed, that Jamaica would have contributed $28 million to that $100 million fund to establish the Caribbean Court of Justice, and that would exist to sustain it. But then we heard opposition telling us that, well, there are going to be other costs. We wanted to hear how those other costs come about. We wanted to hear greater assurances that we'll be faced with other costs. So and what is the quantity, what is the quantum of those other costs, so as to convince us that those other costs are actually real, one, and two, worthy of consideration against us moving towards the Caribbean Court of Justice. Now, ladies and gentlemen, with all that said and much more, and the teams can get much more when they meet with us for personal feedback, but when we would have deliberated on the debate, we came to the decision that the team that did a little better at proving the points that they were seeking to prove, not releasing any information quite yet, is the team that won the debate. And that team, ladies and gentlemen, is Team Proposition. So congratulations to the team from Jamaica Information Service. And dare I say, the team with the boss, congratulations. Of course, we want to give an astounding round of applause to the opposition team. Ladies and gentlemen, it is with deep regret that I have to send the opposition team home. But I tell you this, you have done tremendously well in this competition, and you have represented yourself and your institution very, very well. And as a mark of your excellence, team opposition, the best debater, the best speaker comes from your team. that speaker is the second opposition speaker. It is always a delight when you get a speaker who demonstrates good matter, manner, and method, good content, style, and strategy, excellent spirit, and excellent content, and she is demonstrative of that. Congratulations. And so, ladies and gentlemen, I'm now relieved to pass the platform over to our moderator, Aniki Clark, who will lead a process towards handing a gift basket to the best speaker.
And so it's only left for me to thank you all for being here and for watching and supporting the teams. I mean, let's give MIC a round of applause again. They are new entrants to the competition, and on your first time to get all the way to quarterfinals, you know, it's impressive. But let's give a bigger cheer to returning, was it third place? Yeah. Third place from 2019, the Jamaica Information Service. And they are through to the semifinals, and your opponent, you will learn at the end of the day, that team will come from a match this afternoon. So thank you very much, ladies and gentlemen. It's sort of a mixed feeling, you know, because the match was so close in my own mind. Well, there you go. Thank you online who have tuned in to watch this competition. We have a match coming up in another hour, so you can check back our YouTube channel and you will see that match. Bye for now. Enjoy the rest of your day. Thank you.
Champion.